We witnessed one of the deadliest air crashes in India on June 12th. Air India flight from Ahmedabad to London crashed immediately after takeoff, killing 241 passengers on board and many others on the ground. Only one passenger survived the crash. Now, the bodies are being handed over to the relatives after the DNA test. The next big procedure is the disbursal of the compensation amount. In this context, we are discussing about the air accident claims with Advocate Arif, a senior lawyer at Arif and Associates, who is dealing with the compensation claims of 2010 Mangalore air crash and 2020 Calicut air crash victims. As you know, Air India Express flight from Dubai crashed in Mangalore on May 22, 2010, killing 158 passengers on board. Only 8 people survived the crash. On August 7, 2020, another Air India Express flight crashed at the Calicut International Airport. 19 people were killed in the crash and 165 people survived. Welcome, Advocate Arif, to the New Indian Express. So let me start by asking you a straight question. Can you explain to us how insurance claims are settled in air accidents?
The basic concept or basic law of disbursement of compensation to air crash victims is Montreal Convention. India is one of the signatory in the Montreal Convention.
Can you explain what this Montreal Convention is?
Its main intention is that there should be a uniform level of compensation to all over the world for the air crash victims. It was held in the Montreal in Canada in 1991. So at the time of the convention, 105 countries were signed in the convention, and India is one of the signatory. So the intention of this convention is that all the people, whether they belong to developed country or developing country, should be compensated in a uniform way. All the countries, after signing the Montreal Convention, all the countries, they have adopted this Montreal Convention to their own local laws. Likewise, India has adopted this Montreal Convention into the Carriage by Air Act 1972 as third schedule. So now the third schedule of the Carriage by Air Act is deciding the compensation to the air crash victims in India.
Advocate Arif, basically, India is a signatory to this Montreal Convention. If an air accident happened in India, how will they decide the compensation packages?
If any death or injury is caused between the embarkation and disembarkation, the carrier is liable to compensate the passenger. As per the Montreal Convention, they have decided a special currency or special currency that called SDR, special drawing right. So one special drawing right in India, it is equal to right now 122.31 paise.
There comes my question. What happened to the accident claims of the victims of Calicut and Mangalore air crashes?
At the time of Mangalore air crash victim is entitled to get 1 lakh SDR. That time the value of the SDR is 90 rupees, 90 in INR. So the amount was 90 lakhs. So the air carrier has to pay 90 lakhs irrespective of the all the victims of the air crash, whether they are injured or dead during the embarkation or disembarkation. The question is whether they have disbursed this amount. In single word, they have not given. But the Air India is adopted another method for disbursing the compensation. They are saying that they are supposed to give only compensation to sustained damage. Only compensation to sustained damage. What the actual damage caused to this victim or his legal heirs. Accordingly, in Mangalore crash, they have given 20 lakhs to 20 lakhs, 30 lakhs, 40 lakhs, 50 lakhs, and for a single passenger they have given 7 crore 45 lakhs. That is Triveni Kotkani versus Union of India. That case was took up to Supreme Court of India, and our former CJ YV Chandrajud has given a judgment, and as per that judgment, the Air India was directed to disburse a high compensation of 7 crore and 45 lakhs. One more aspect for in that Mangalore air crash, they were not ready to give this amount as no for liability. The one of the victims, one Mr. Abdul Salam, his son, age 24, he was dead in that crash and leaving his father, mother, and two siblings. And they have approached Honorable High Court of Kerala for getting the compensation, and the compensation amount was paid only rupees 20 lakhs. He has just received as an interim compensation, and he has approached the Honorable High Court of Kerala. And in that judgment by Justice P.R. Ramachandramana, in that judgment, it's crystal clear it is stated there are two level of compensation. One is first tier liability, that is now for liability, and the second one is the second tier liability. Second tier liability means that is actual sustained damage. The first tier damage, first tier now for liability has to be given to all the persons, and the second tier liability compensation has to be considered according to their income, loss of income, their age, etc., etc. What we are calculating in a motor accident claim.
You just mentioned about the Mangalore air crash claim. And can you tell us what happened in Calicut air crash?
So legal battle has already started by the air crash victims of Mangalore. So that is still pending before the Honorable Apex Court of India. Calicut ill-fated air crash was happened on 7th August 2020. After that Calicut crash, the attitude towards disbursing of compensation by Air India was little bit better. We have taken up the first matter before the Honorable High Court of Kerala. That time itself, they have offered an amount of 1.1 crore and 51 lakhs as compensation to an injured persons.
That means Air India has complied with the Montreal Convention.
We cannot strictly say that Air India has complied the Montreal Convention. Air India has given a handsome compensation for the second tier liability, that is for the actual sustained damage, for the injury, for the pain and suffering, for the mental trauma, for the loss of income, for the loss of amenities, for the loss of employment, for the compensation for disfiguration, compensation for permanent disability, compensation for temporary disability. All these heads, they have given a better compensation compared to Mangalore air crash. But still, the Air India authorities were not ready to give a minimum compensation or no for liability to each and every person, whether they are dead or injured in an air on the board of aircraft.
How much is that no for liability compensation?
That what we are saying, according to us now, argument is that what we have put forward before the High Court and Supreme Court is that now an amount of 1 lakh 20, earlier it was at the time of Mangalore aircraft, the SDR was 1 lakh. In each and every 5 years, all the signatories in the Montreal Convention, they will meet together, and it will gradually increase. It depends upon the inflation and etc. and some other factors. Accordingly, it was from 1 lakh, it was enhanced to 1 lakh 5,000, then 1 lakh 13,000. Now it is enhanced to 1 lakh 28,841 SDR. This will come around 1 crore 57 lakh 56,000 rupees. This has to be disbursed as an interim compensation to each and every passengers. But this
whether died or whether injured, everybody has to get it simple.
Get. But still, even in the light of the Ahmedabad air crash, this Air India has not complied or not agreed to disperse and offer liability.
Air India is not complying with that. What is the reason, Advocate Arif?
That Air India has prepared an appeal before the judge, before the division bench. In that judgment, Honorable Justice C.N. Ramadhan made a judgment that there is no such system of no-fault liability. So only the sustained damage has to be given after considering all the economic and non-economic loss of the deceased or the insured. On the strength of that division, with that judgment is prevailing right now. And against that judgment, we have preferred an SLP before the Honorable Supreme Court of India in the year 2011 itself. And at the time of SLP admission, the prominent lawyer Harish Salve was appeared on behalf of the petitioner. Now it is pending before the Honorable Supreme Court as civil appeal number 8128-8132 of 2018.
Air India is getting the amount from the insurance companies. And does this mean that Air India is reluctant to pay it to the victims? So they are getting the money, but they are not disbursing it to the victims.
Same question was put before the Honorable High Court while considering the writ appeal. They have given a statement that we are not getting the whole insurance amount in our pocket. What we are doing, what insurance company is doing that after the negotiation, the negotiation of each case, the final figure will be approved by the insurance company concerned, and towards against that settlement of amount, they will directly transfer to account of the Air India, and Air India will transfer the same amount to the concerned persons. So we cannot say that they have pocketed all the insurance amount from the concerned insurance company and they have not disbursed to the passengers. That's we are not able to answer right now.
According to the latest reports, the insurance claims this time would be worth around $475 million. So this time, do you expect all the victims will get a fair compensation?
They have to disburse the fair compensation. The compensation calculation compensation may be much little bit better compared to this Mangalore and Calicut Aircrash, because another aspect is that 56 foreigners included in this ill-fated Ahmedabad aircrash. So the yardsticks will be different. So they cannot give a nominal compensation to an UK citizen or some other Portuguese citizens. So it should be compensated adequately, in a fair compensation has to be provided. So that benefit has to be given to Indian passengers also. In Calicut and Mangalore Aircrash, in Mangalore Aircrash, they have offered interim compensation 10 lakhs to deceased person's family. In Calicut also, after 10 years, it was happened in Calicut. So they have offered only 10 lakhs as interim compensation to the deceased person, and 2 lakhs interim compensation to the critically injured, and 50,000 for the persons that are injured. But now, Ahmedabad Air Crash as an interim compensation, how much they have offered? 1 crore rupees. No, it is, I think it is enhanced 1 crore 25 lakhs.
You are saying the victims of other air crashes, including Mangalore and Calicut, haven't got a fair compensation when you compare it with the Ahmedabad crash.
Yes, so that is very clear, because
so how many people are still fighting for justice in our courts?
That is around 125. 43 of Mangalore air crash victims and around 80 of Calicut air crash victims are still fighting against the compensation awarded by this Air India.
And their cases are pending in Supreme Court or in Kerala High Court?
Out of this Mangalore air crash, 2 cases are pending before the Honorable Supreme Court and 41 cases are pending before the Honorable High Court of Kerala. And in Calicut air crash, around 75 cases, 76 cases are pending before the Honorable Supreme Court.
So one final question: when the Mangalore and Calicut air crash happened, the Air India was under control of Ministry of Civil Aviation, or it was a public entity. Now the Air India is governed by Tata Group. So do you expect any favorable move from the the new management, or are you in touch with the Tata Group for fair compensation?
We have implemented Thales as third respondent, and they have appeared before the Honorable Supreme Court, but they also not given a positive. They have not given filed any counter in a positive manner, disbursing the non-fault liability. But in the light of the Ahmedabad air crash, we can see right now. So the attitude of the Tata Group is a little bit better compared to Calicut and Mangalore air crash.
You are expecting a favorable judgment from the Honorable Supreme Court and Honorable Kerala High Court for the victims of the 2010 Mangalore and 2020 Calicut air crashes.
Definitely, we are expecting a positive verdict from the Honorable Apex. Battles continues for getting justice to these people.
Thank you, Advocate Arif, for explaining in detail the compensation of the air crash victims in Karnataka and Kerala. Thank you so much once again.
Thank you.